Altnabreac Towers, News Channel. News from Caithness, Inverness and Edinburgh. Disposition by British Railways Board to Robin M. Sinclair recorded GRS, Caithness, the 13th of June, 1969. This post is about the driveway, or station access as it should be correctly described. I have put this together to show my understanding of how the 1969 disposition affects the registered title situation in any future court case that Network Rail, NR, may decide to bring, and what I ultimately expect to happen, and, hopefully, it should also help recent subscribers to the channel. Apologies to the old hands for the repetition of points from the posts from Altnabreac uncovered, or, please note that the detail I've added to the plans referred to is plotted approximately and, obviously, not drawn to scale and is intended to be indicative only. However, I can say it won't be too far away, but this exercise would be more accurately carried out using the NR survey result. Indeed, I trust NR's solicitors will have already done this. I have assumed that the footprint of the house on the east side is the same on the map as on the ground, and as that shown on the 1969 deed plan. It doesn't look like the footprint of that side of the building has changed between 1969 and now. Bear in mind that the land register title plan is based on the 1 to 10,000 base survey scale, and is liable to some error as a result. Another reason why it would be preferable to use the NR survey detail. The 1969 disposition can be viewed here. Print 1 shows the 1969 disposition's exclusive subjects, 0.34 acre, plotted as edged blue. This conclusively proves that the station access was deliberately not included in the title. Print 2 shows the current extent of the registered title edged red on the said print. The station access has been included in the title, erroneously in my opinion. Print 3 shows the extent that should, by order of the court, be removed by rectification from the registered title CTH 7726 on conclusion of the court case. The extent for removal is shown edged green thereon. If NR's solicitors are successful in making their case, based on the fact that any land out with the extent of the 1969 disposition could not, and should not, have been included in the registered title CTH 7726, and the two previously registered titles, then the court can instruct the keeper of the land register to rectify the registered extent to remove the station access edged green on print 3. In other words, in Scots law, the deeds that created, firstly CTH 5589, then CTH 7265 and finally CTH 7726, were not habeal to include the land edged green on print 3. In Scots law, habeal generally means fit, valid, or competent for a particular purpose or situation. In my opinion, it will be a relatively simple task for NR's solicitors to prove to the court that the green edge land's inclusion in the three titles was not fit, not valid and definitely not competent, and thereby making the court's decision to rectify the title relatively simple. From the keeper's knowledge base, we have a duty to rectify the register where we become aware of a manifest inaccuracy. The rectification action we must take is also manifest. Manifest means perfectly clear and not reasonably disputable. Both the inaccuracy and the rectification action need to meet this standard. The manifest test means that the keeper has power to rectify only if it is perfectly clear, and not reasonably disputable, that there is an inaccuracy in the land register. In cases where the parties do not agree that there is a manifest inaccuracy, the keeper is likely to require a judicial determination by the lands tribunal, or the civil courts, that the relevant maintenance burden is invalid. There is no doubt in my mind that the inaccuracy in CTH 7726 is manifest, and will meet the court's requirements to allow instructing the keeper to rectify. It seems clear to me that the inaccuracy is not reasonably disputable. However, Appleby and Howe will almost certainly dispute it. If the court makes the judgment to rectify, then what they think is, to quote one of Howe's favorite sayings, irrelevant. I'm sure they can appeal, but the rectification will have been made by then, and the land returned to the rightful owners, Network Rail. I don't see how Appleby and Howe can bring any new and or compelling evidence to an appeal court that would change anything. I admit to being a bit confused by the keeper including the phrase that the relevant maintenance burden is invalid in the conclusion of the manifest test paragraph. I think this has been included in error, simply an example, an oversight on her part, and it could have read that the title extent is inaccurate or anything else, as applicable. Not important in my view. Print 4 shows the extent of the part of the station access over which the 1969 deed grants a right of servitude right of access to the proprietors of Station Cottage. I have shown that part as colored brown and red on print 4. Please note that, as things stand, NR can't actually grant anything over the land colored red as that is part of the Forestry Company's registered title CTH 3449. Hopefully this can be taken to be part of the estate roads over which they already have rights of access, as stated in their title sheet. This is a problem for Appleby and Howe on another day. Also worth mentioning, no part of the cattle grid was included in the 1969 disposition. Also worth clarifying, the part of the Station Cottage building I have colored green is part of the land retained by the Railway Company in the 1969 deed. I've already stated my assumption that I don't think the footprint of the building on that side has changed since 1969, but there does seem to have been internal changes. I imagine the green part was retained for use as a store, and it seems reasonable to assume it was not accessible from the inside in 1969. There is a window that seems to span the mutual boundary, the 8 feet 0 inches boundary in the 1969 deed, suggesting it is now accessible internally. There is no longer any external access. I don't imagine that NR would push to have this restored to their occupation for their use, but legally, it belongs to them. If needed, it could prove to be a strong bargaining tool for them. The part I have colored blue on print 4 is exclusive title and was included in the 1969 Station Cottage deed. Therefore, on rectification, it should be added to CTH 7726. Thanks for watching. Keep following the channel. Altnabreac Towers@gmail.com.